Imagine your phone company contract, 47 pages long, no negotiation. You have to accept the contract or you don't have phone service. Is that a real binding contract? Hi, I'm Michael Dorff, and I'm the Executive Director of the Lowell Milken Institute for Business Law and Policy here at UCLA School of Law. In the next few minutes, I'll explain contracts of adhesion and when courts protect you from take it or leave it deals. The legal term for the day is contract of adhesion. These are usually long, complicated agreements set by one party with no negotiation, where the other party, often a consumer, has no choice but to accept the contract or go without some very valuable good or service. Think of examples like insurance contract, utilities, software updates. All of these are usually contracts of adhesion. The consumer usually hasn't read, certainly hasn't understood these contracts. Are they enforceable in court? The surprising answer is yes, they usually are enforceable in court. If you click that I agree button, you are bound to the terms of that 47-page single-space document written in language that might as well be Greek to you. There are, however, some exceptions designed to protect consumers in these circumstances. The first exception is for terms that are unconscionable. That's our second legal term for the day. Unconscionable means shockingly unfair. It can't just be a little unbalanced or a little unfair. It's got to be so bad, so one-sided that it shocks the conscience of the judge. Unconscionable terms are not enforceable. The second exception is for terms that are important, but they're hidden inside the fine print, and the terms themselves substantively would be a big surprise to the weaker party, which is usually the consumer. When all of that is true, courts might invalidate those terms as well. And finally, the third exception is for public policy. Terms that clearly violate public policy will not be enforced by the court. Some examples of terms that courts have said are not enforceable if they're in a contract of adhesion: a term that says that the stronger party can change the terms whenever they want to, not enforceable. A term that requires the consumer to pay a grossly inflated price, not just 10 or 20% more, but many times more than the market price, not enforceable. And finally, a term that says you waive your right to sue for gross negligence, that's a term that is not enforceable either. What are some terms that courts do usually enforce on contracts of adhesion? Ordinary pricing terms, standard pricing terms that are within a reasonable range of the market price. A clear and fair dispute resolution procedure, like arbitration or mediation. And finally, industry standard warranty limitations. Those are also usually enforceable. In summary, contracts of adhesion are usually valid, but courts may not enforce terms that are a surprise to the consumer and are shockingly unfair. What's the most unfair take it or leave it term you've ever seen in one of these long contracts of adhesion? Comment below and follow for contract law that actually makes sense.